13 on your side, breaking news now.
Good afternoon, I'm Elena Holland. We have breaking news right now on 13 on your side. We have just learned Kent County Prosecutor Chris Becker says he will not be pressing charges in the shooting death of Daquan Johnson. Johnson was shot and killed by a Grand Rapids police officer following a short chase in February. He's holding a news conference on this decision right now. Let's take a listen in.
You all have a copy of the actual things that I'm going to play here, but just to be forewarned, I will be playing this. The biggest thing is, when it comes down to it, I cannot show that the decision of Officer Christopher Carlson of the Grand Rapids Police Department to use deadly force that night was not honest and reasonable. Putting it another way, in terms of when a self-defense claim or defense of others claims is raised, I have to prove that beyond a reasonable doubt that they did not act in self-defense. And based on the facts and circumstances as I see them, I just cannot simply do that, even with that as bad as those videos show. The facts show that Mr. Johnson had a firearm. It was a loaded firearm, and from the impression of Officer Carlson, it was pointed at him during this incident. So I'm going to get into that, kind of starting from the beginning, when I started the review. How did this incident start? This was actually started by a confidential informant. They have a reliable and confidential informant by the Grand Rapids Police. The Vice unit was out that night conducting operations. They got a tip. They got a tip that an individual would be walking around the city with a loaded firearm. Actually not a loaded firearm, but just a firearm simply. And so they started to investigate. They conducted surveillance, and they actually picked him up around Miss Tracy's. When I say picked him up, it was Mr. Johnson. He matched the description. They've used the informant before, and they actually have the Vice audio that kind of gives you a little bit of background on what was going on.
Like he's going to go into Miss Tracy, but he's not going to. Yes, he is. He's going to go into Miss Tracy.
Austin and I will tighten up, call it when he leaves, when he steps out into the parking lot, and we'll move in.
Pretty loud. Again, DM, medium build. He has like a tan flannel with black underneath, black pants, black t-shirt, with tan hat. Looks like he's ready to grab that bike there. He's going to be riding that bike westbound on MLK, 10 of them now.
Yeah, I'll be behind him, I guess. I've got him. He's singing real loud. He's westbound on the bike. I'll have him for a minute. No lights on that bike, so if he gets in the roadway, we'll be good.
So you hear that last thing, if there's no lights on the bikeway, if he gets in the roadway, we'll be good. It is a violation of Michigan law. It is a violation of Grand Rapids City ordinance to ride a bike in the roadway without a light. It did not have a light, so there's a legitimate basis for them to make contact and pull him over for not having a light. In addition, when there's reasonable suspicion under Michigan law, even using a confidential informant, you can conduct an investigatory stop. And I'll quote from People v. Tooks. It's 403 Mich. It's a Michigan Supreme Court case from 1978. Even when an investigatory stop is based, at least in part, on information from an informant, the critical inquiry remains whether the officer's suspicion was reasonable when considered in light of the totality of the circumstances. And this basically follows Terry versus Ohio. That's a United States Supreme Court decision, which basically says a reasonable suspicion test for determining the reasonableness of a stop. So they had a reliable, credible informant. The information that was provided to the vice officers gave them a reason to follow this guy. The information checked out. He went to Miss Tracy's as they were informed to. So they decided to make a stop of Mr. Johnson. What you see here and what you have a copy Canine officer that was involved in this incident. We have his in-car video. Officer Carlson was operating a semi-marked. You'll see it up in front here where my arrow's pointing. It's got sirens and lights, but it's not fully marked, nor does it have in-car video. So all we have is the in-car video of Officer DeGevers as they attempt to stop Mr. Johnson. You can see Mr. Johnson right there riding his bike when they attempt to pull him over. Going down Eastern here, this chase goes from Eastern to Bates to Henry to Thomas to Charles, and then ends up in the apartment complex.
Stop, please, canine! Stop, please, canine, you're gonna get that.
You'll hear that he actually went on that one. He went over the PA system saying, "Stop, police canine, you're going to get hit." The other two times, was yelling out the window, but he just went one time over the PA system.
Henry, yeah, black male, brown flannel, black pants, he's got a brown hat, he's got a satchel. We are still, we're northbound Fort Thomas.
He's going.
Stop, please, Levi!
Northbound Charles. And we're in the back lot of the apartment complex. Dog on bite, dog on bite.
Okay, so that's the in-car video of Officer DeKeevers and his K-9 unit. This is a video I don't think anybody's seen yet. This is an apartment complex security video that the police, Michigan State Police had access to. You'll see much of the same thing. There is no sound with this, so you see it run. As you can see, the officer allows the K-9 unit out. The K-9 is trained. This is a K-9 unit. They are authorized to try and apprehend suspects, a fleeing suspect in this manner. So there's nothing in violation of Grand Rapids Police policy. They have a policy that says they can use reasonable, when there's reasonable cause to think they need to chase somebody down with a dog. They were able to use that in this fashion. I think this was probably the clearest video in terms of quality, and I think one of the things that we're able to do, once again, the state police did a really nice job in terms of pulling out some information. One of the more important things is when you look at these still photos from it, you look at Mr. Johnson's hands, and I'll try and use hopefully my cursor shows up there. Maybe it is, maybe it's not. But you can see in the lower part of his, there's nothing in his hand. That right hand is a key thing. If you've seen the body cam on the right hand, there's nothing in his right hand at this point in time. There are some in his left hand. Those are a pair of gloves. That's nothing dangerous or anything along those lines. But when you look at it, he clearly has nothing in his hand. One of the things they talk about, the officers talk about, is the 45-degree angle. This is in the reports. This is something that both officers indicate that caused them concern. You can see in this video, there's a 45-degree angle. It's indicative of somebody reaching for something, and that's something that's trained in. That's something that's well known in the police community. When somebody's reaching for something, you don't know if it's a gun, it could be a cell phone, could be nothing, but that 45-degree angle gives officer concern of, okay, what's that person reaching for? This comes out a little bit better because we were able to go in further, and you can see once again he does it twice. Right about now, reaching to the side, and then he does it again. And you can see the officer stomp down. That is a staple. That is a trained thing. He stomps down on that right arm. He is concerned about it at that point in time. I'll get into the body cams a little bit, but you'll hear him saying he's reaching for something. He's reaching for something that's got his arm. So that right arm gives him concern because at least on 2 occasions, Mr. Johnson is reaching for something with his right arm. He didn't have anything in his hand when he fell off the bike, but he's got something. He's going for something, and they don't know what at that point in time. And then you see when it comes out, something falls out of his hand. That's something you can't see very well. This is about as clear as we can get it from this video, but there'll be additional videos that come out as this transpires. So I then go to, once again, this is maybe a better shot of, once again, as he's on the ground with that 45-degree angle, you see that bent arm, which caused the officer to stomp down on his arm in that fashion. So then you have the body camera video. Much of this is just, what you've heard before. This is Officer DeKeevers' body cam. Officer Carlson had a body cam. It was not activated. He was in the semi-marked patrol vehicle. They don't have the same synchronizing thing that makes the body camera turn on at the same time the sirens go on. So he turned his on after the incident essentially happened. So all we have is the body cam of Officer DeKeevers, but there's a lot of stuff here. This is when, as they begin to chase him, so I'm going to fast forward to this. You can see him stomp, and you can see his foot on that arm rung.
Grab his right arm. I need you to grab his right arm, Chris. Grab his right arm. I got the dog. Dog's good. Hey, dog's good. Chris, right arm. Right arm. Stop reaching, man. You're gonna get shot. Hey, he's got a fucking gun. He's got a gun in his hand. Let it go. Let it go. Drop the gun. Drop the gun. Drop go. Chris, you good?
So obviously there's, both officers say that right arm, and now you see the gun is introduced. He's reaching for a gun. He's got a gun in his hand. Obviously that causes concern for Officer Carlson. He expresses that to Officer DeKeevers about the dangerousness of this gun being in his hand. So the question becomes, is there a gun? Is there in fact a gun? Because clearly you don't see it under the cameras up until this point. We also have the cell phone video, and this maybe gives the best view of, is there a gun? We did remove the sound from this. But at the end of this video, I think clearly that shows, when we review this and you can go into it, there is a gun that comes out of his hand at that point in time. It's kind of fast there, so I'm going to back that up. Just right there as it comes out of his hand, you can see that it's a tan Taurus right there. You can see something drop out of his hand. So clearly he's got a gun in his hand and obtained a gun, because as I showed earlier, there was no gun in his hand when we got off the bike. And so now we know what he was reaching for. He's reaching for a gun. It is a loaded gun. It's a Taurus handgun. It had a round in the chamber. We don't know much about it other than it was sold in Georgia, and we don't know anything. It was not reported stolen or anything along those lines, but clearly has a possession of a gun, and it drops out of his hand after this incident occurs, which once again supports what Officer Carlson said. He's got a gun. We have a gun now falling out of his hand at this point in time. We tried to get some stills off of that. Obviously the quality's not there, but you can kind of see the framework of a gun coming out of his hand. This is once again off the cell phone video. The cell phone video, and it kind of matches what you see in the apartment complex video. Something's clearly coming out of his hand. This is the best we could do coming out of it. There was a gun found next to him then, and I'll show you a video of that when the officers report to aid him. The gun is lying next to him on the ground, and that's a close-up of that gun that was found next to him on the ground. We did do a sync video because I thought that would maybe the best way to show what exactly was going on, kind of putting all this together. They use the audio of the body cam videos, but then they try and sync the other camera angles of what exactly occurred, and I think it becomes really apparent in terms of what exactly happened when that gun was seen by Officer Carlson at this point in time.
Look! Get on the ground! Hands up! Look, hey, show me your hands! He's reaching, Chris, he's reaching! Chris, grab his right arm. I need you to grab his right arm, Chris. Grab his right arm. I got the dog. Dog's good. Hey, dog's good. Chris, right arm. Right arm. Stop reaching, man. You're gonna get shot. Hey, he's got a fucking gun. He's got a gun in his hand. Let it go. Drop the gun. Drop the gun. Drop go.
Now, it doesn't come up when you get closer, but you can see a gun once again. You see the outline of the gun coming out of his hand at that point in time. But I think one of the most important things, too, if you watch the cell phone video, is the kind of a hop. When you see he's got a gun, Officer Carlson had holstered his weapon, had put his weapon away to effectuate an arrest, and he says that in his report. But then he does this hop, he's got a gun, and then draws his weapon once again. So clearly, not only verbally does he see a gun, but I think there's a physical manifestation of what he sees there, because clearly there's a start, there's a jump, if you will. So it becomes, okay, there's a gun, did he see it? And obviously I get feedback, and I've heard the things that, well, they make this up. They're trained to put this in the reports. But we look further in the body cam video, and you hear Officer Carlson minutes after this saying, the gun was pointed in my face. I'll show you the first one. That comes a little bit later. After you hear him say, one of the Officer DeKeevers said, stand back, please. Or stay inside.
Stay inside, please. Val. Do you see the gun, Chris? Yes, the barrel point is still in my face. Okay. Do you see it right now? Okay.
I think it's interesting right there. The conversation is, do you see the gun, Chris? And that's a question, and the answer by Officer Carlson was, yes, it was pointed right in my face. Okay, I think the question actually was, do you see it now? Because that's what he follows up with. Do you see it now? And yes, it's going to be on there. But that was, goes to, this is minutes, probably 2 minutes after the actual shooting. He says, yes, the gun was pointed in my face. And just in case we didn't hear, we were able to kind of take out the siren portion of that video or the audio to hear it a little bit more clearly. So yeah, it's going to be under him. Barrel's pointed straight at his face, and there in fact was a gun. This is a little more of a graphic portion of the video. We blocked it out as much as we can, but when ground officers go to assist and with Mr. Johnson, the gun is found right next to him. It's caught on the body cams.
Roll him away from the gun.
So the gun's clearly next to him. So when analyzing this, I can't just say, well, look at this video, it's horrible. Everybody's offended by it, because a lot of people are, and I completely understand why. It's a horrific video to watch. But I have to apply the facts to the law when I argue this into a jury. And so what are the elements of a second-degree murder? Because that's what we're looking at here. There's a death caused by the defendant, Officer Carlson, and the defendant had a state of mind, an intent to kill or an intent to do great bodily harm. And I have to say there, shooting somebody in the back, and this was in the back. The two shots were in the shoulder blade. It was not in the back of the head. The two shots went through the shoulder. One of them went through actually the spinal cord, which was the fatal shot. But he shot him in the back, and so the elements there are, for those three things are set, and it's the fourth one. And I'm sure everybody makes a comparison between this and the Leoya case, but that was the thing the trial of Leoya was about. It becomes this fourth thing, self-defense. The fourth thing, I have to prove beyond reasonable doubt that the shooting was not justified or excused due to self-defense or defense of others. They're pretty much the same thing under the law, but when you look at this, we have to show first, at the time the defendant must have honestly and reasonably believed that he was in a danger of being killed or seriously wounded. Well, is that honest? Well, you look at that video, you listen to him saying there's a effing gun, and then afterwards saying, yeah, the gun was pointed right in my face. Is that an honest belief? I don't see how I can argue that that's not honest. That gets you 50% there, right? 50% there saying, holy cow, I just saw a gun, it was pointed in my face. So is it reasonable? Okay, is it reasonable then to react in the way he did based on having a gun pointed at him? And you go to the second part of the jury instruction. This is what would go to a jury. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. Okay? Well, what evidence? What can you consider? Okay, jury, consider whether the person was armed with a dangerous weapon. He was. I would have to concede that. He is armed with a dangerous weapon. He's got a gun in his hand. We've seen the gun in his hand. The gun comes out of his hand. It's a loaded gun. And so, all right, great. So, is that reasonable to, try and shoot somebody in defense because somebody you don't know and has been struggling with you for, going on 2 or 3 minutes at this point in time, to fire at him to try and stop that? There is no necessity under Michigan law that a gun has to be pointed at someone to effectuate self-defense. It's reasonable under the totality of the circumstances. He's fought. He's never said anything. That's one of the more important things. He's never said, I surrender, I'm giving up, I'm dropping the gun, because I think that's a natural question, right? Okay, it's underneath him. How do they know if it's dropped or not? They didn't, it was hardly enough time to see that. But he never said, I'm surrendering. And once again, that may change things if he had said that, but he never did. So we have an individual who clearly accessed a weapon, pulled it out. What he was doing, I don't know. He may not have known. You'll see from my opinion, he was under the influence of cocaine. He had cocaine in his system. So he may have not been thinking clearly, but we don't know, but the officer clearly doesn't know. And so if he's got this person armed with a dangerous weapon, what is he supposed to do? What does he do? What are the options? What do I argue? Well, he should have laid on top of him. I don't think there's anybody here that would say that's a real good option. He's supposed to push off and maybe run for cover. That you're releasing him, and then so he's going to turn and potentially fire his weapon. There's not a whole lot of good options at this point in time. And once the law says we can't second guess. We can't say, well, he should have done this, he should have done that. He could have. Yeah, maybe he could have, but is it reasonable to fire at somebody who is pointing a gun in your face, as he said? And I don't know how we come down and argue that in fact it's not. And then partially the last instruction there, you may all consider how the excitement of the moment. Okay, so it's not like it's all easy for us here to be here and make these arguments, but what was going through the officer's mind? He's been pointed, gun's been pointed at his face. How is he going to react? And I know there's comparison once again to the Yoya case. I think there was a basis to make those arguments because we're dealing with a taser that had been completely used up at that point in time, and what there's a question. I think there's a legitimate question of whether it was a dangerous weapon or not, and obviously I couldn't convince a jury of that with a used taser, much less now we have an armed gun, and we're putting an officer in the situation that he's supposed to do what? And I don't think we can overcome the defense of self-defense based on these facts and what was going on at the time. Some of the things to address as well, I think it's fairly consistent. This decision is consistent with other decisions I've made. I brought some other ones. We went back to, back in, what's the other one? Sorry. We had one in 2018. There was a shooting at the security guard at the Le Petit Chateau on South Division. He thought a person was drawing down on him with a gun. Turned out he had a cell phone in his hand. I excused that individual. There was a homeowner in 2025 that had somebody on his back porch. They thought he had a gun. He was running away, thought he saw a gun, fired rounds. Fortunately, nobody was killed. I cleared that individual. Those are all, I've made these releases, so those are all out in your library somewhere, but I made releases like that. I think that once again, there's one last year that happened right after. It's on the Grand Rapids, Inside TV show. The Tin Can. We had a brother walking out in a parking lot across the street from a tin can. A man draw down on him, pointed a gun at him. The brother, standing behind him, the brother's actually the one that fired the first shots. I did not charge that brother for firing the first shots because his brother had a gun pointed at him. So this decision is consistent with just about any other decisions I've made. I think there is something when somebody's pointing a gun, you're messing with guns, and you point them at somebody, anybody, be it police officer or civilian, it's extremely hard to overcome this self-defense. We've lost a few jury trials recently on murder cases, and self-defense is the issue. It's a very high burden. We have to prove beyond a reasonable doubt they did not act in self-defense. And I just don't see how we do that on the facts here. So that is the decision I made. I talked with the family. I made a phone call just before this press conference to let them know my decision. And that's all I have at this point in time. Obviously, I'll take some questions.
Can I ask, is there anything else GRPD could have done to avoid this situation, or anyone could have done to keep it from getting that far?
I don't know, because you saw in the video they tried to cut him off twice. When somebody's trying to run away, there's only so much people to do. I suppose they're terminating pursuits very often in car chases because those are extremely dangerous. This is not the same thing with a police chase. They released a dog. There's very often dogs do solve the problem. People don't resist dogs and they don't continue to struggle. So that's a difficult question to look, what could they have done differently? I don't know. I can't see where, like I said, there's nothing policy-wise, law-wise, there's nothing factual that I could say that, geez, they should have done this. And once again, it's hard to second guess. They're reacting as things are going on, and they have an individual who they believe has a gun, and with his behavior, only heightens that suspicion because yes, he's running away. Why is he doing this if he's doesn't have a gun on him?
This is the first time that we're actually seeing the video of Johnson reach for that gun, like you said, twice there. Just wondering why that video was never released beforehand where we could actually see. That's not
I have not released any videos. That was for Grand Rapids Police. I kind of stay out of it in terms of what they release. I have not. I talked to the chief yesterday real briefly to say, yeah, we're going to be making these released tomorrow to give him a heads up. But that's about it. So what the decisions were, that's not my call.
And we can see him reach for the gun, like you said, twice. And then we can hear the statements of the officer that he had the barrel pointed right at him. Are you in fact saying that Johnson did point that gun at the officer?
With the evidence I have, I can't disprove that. That's what I'm saying. That's what the evidence shows. He definitely does that hop. He says it right afterwards. Yeah, we don't see it, and unfortunately I think that's in this society. Well, if it's not on video, it didn't happen, right? I have to go by the evidence, and all this is evidence that seems to indicate that. Maybe it was not, did he mean to point it? Maybe it was just out. I don't know, but clearly the officer perceived that, and that's what I can't disprove.
When it comes to the confidential informant, obviously Johnson shouldn't have the gun. He was on parole. He had a current charge in circuit court or district court.
They had both. It was circuit and district court.
So when it comes to this situation, did the confidential informant have any reason to want Johnson in trouble with the law?
I don't know. That's not. I don't get into that. Confidential informants are kept from us as well. I just know there was information from a confidential informant.
Now,
So that's all we
The
had.
attorney for the officers has said that they did not know who he was.
Did not know who Johnson was?
They did not know. The officers.
Yeah,
involved did
there's
not.
no evidence. There's no evidence they knew who Johnson was, other than they got this tip that this individual that matched the description of the flannel coat, hat, black, as you heard, would be walking down with the.
And when did they find out it was Daquan Johnson who was a felon in possession? After the
After,
shooting?
clearly after. That's what we found out, that he was actually a felon in possession, but they just knew somebody had a weapon. At the time this was going on, they didn't know he was a felon. They just knew somebody had a gun, a concealed weapon on him.
Can you explain a little bit about the body camera footage one more time when it came to the other officer? We didn't see it.
It's if you're when you're in a normal police car, this is my understanding, when you're in a fully marked patrol vehicle, there's a sync between the body cam and the lights and sirens going on. In the semi-marked, the undercover car, they don't have that same switch. That's the explanation I was given. It just doesn't, and you have to do it manually. He did not do that until after the incident.
And that was a vice car?
That was a vice car. I don't know, a vice car was an undercover car. I don't know if it was vice. It was something used by GRPD, obviously.
Chris, we've heard from people a lot in the wake of this that having a gun on you doesn't mean that you deserve to be shot, but there's a lot of factors that go into this scenario. Can you just articulate a little bit about why the belief of the officers that he did have a gun in this active situation is important?
Right here, I mean, that you go to the instructions, that's what it says. Does somebody reasonably and honestly and reasonably believe that they're in danger? Okay, just because somebody has a gun doesn't mean you're in danger. If the gun's holstered, gun's away, and you're not doing anything with it, you don't meet that test of honestly and reasonably believing you need to use deadly force to protect yourself. When somebody's pointing a gun, the gun's out, then that raises that level. Now, just because gun's out and you're holding it here, does that mean you can just haul off and shoot somebody? No, because and I get these questions a lot. Well, tell us when you can use self-defense. It all depends on the facts and circumstances, and it changes a little thing one way or the other, but the biggest thing is right here. You have to honestly and reasonably believe you need to use deadly force to protect yourself, and given the facts here, that's why it comes down in that way.
When it comes to this case, say he was face down with two officers on him and a dog, and his right arm beneath him with a gun. And is there, I mean, as far as pointing the gun at an officer's face, I mean,
but if you
watch the video.
If you watch the video and go back, and you have it, I suppose you can go back, but when this happens, he's down looking. I mean, the officer's trying to arrest him, and when he sees the gun is when he's bent over looking at him. So we don't have a good shot of that, but at the time when he's the only one bent over looking at it, that's when the gun was pointed. We're not saying he pointed it right before this happened, but from the officer's view, he clearly saw that gun, and that's why you see the hop, and he jumps up and rearms himself.
But at the time the shots were fired, I mean, that's when he's face down. Is the dog already not, kind of ended that threat or no?
No, not at all. The dog's on the left arm, the right's arm. The only thing we got on the right arm is the officer's arm, or the officer's leg is stomped down on it. So, end the threat, somebody's still armed with a weapon, that's not ended until he's completely disarmed. And to say, well, you have to, only at the moment, you're arguing that at the moment you see the gun, that's the only time you can use deadly force, and that is not the law in Michigan. It's reasonable under the totality of the circumstances. So they don't even need to have it pointed at them under the law. If it's reasonable under the facts and circumstances, and that was seconds afterwards, like I said, I go back, what else are they supposed to do? Lie on top of them? I mean, I just don't know what other options they have too much. I mean, they would have been a hero, that would have been a great thing, and maybe that could have happened. But to say, now we're going to charge them with a crime because they decided to fire when somebody's pointing a gun in their face, I think it was 6 seconds earlier, that's a pretty thin line.
When it comes to, just to get clarity, do you think these officers acted reasonably or just couldn't prove otherwise to where they were in need of charges?
Yes. I mean, I think it's both. I mean, I don't think you can't separate it necessarily. I think under the circumstance, I can't disprove it clearly. And like I go back to, what else would you have them do? I can't. It would have been great if they would have done something else, but I think I can't prove it. And given all the facts and circumstances, it's hard to say what they could have done differently.
How did the short trial impact your decision on this case?
Not really. I mean, other than, I have a little bit of a basis. I mean, yeah, there's comparisons and everybody says that. But, going back to, geez, I couldn't do it, with a taser that had been discharged twice. That did factor into somewhat, but I think that leaning towards, once again, going back to your first question, this is a different case because he's got a gun. And a gun raises the stakes a whole lot. And it's, I think there's a lot more leeway given in those circumstances when somebody's armed.
We
Chris,
can't
I may
ignore
have
the
missed
fact
this
that
in the, I'm sorry, I may have missed this in the statement. The cell phone video that was taken, was that from a bystander, from another officer?
It was an apartment. Somebody, it was a bystander. It wasn't other officers, it was just a cell phone video.
Now, the community, some members of the community have asked to have the Attorney General's office take a look at this. I don't know if you've been asked that directly,
Nope.
but they've told us
Nope.
that they'd like the AG's office to look at that. Can you talk about?
I don't understand why. I mean, part of the reason is, I don't know if there's anything different the AG would have done because they just got done with clearing, I think it was an Ingham County Sheriff. They cleared an Ingham County Sheriff for an officer-involved shooting, except that incident happened in April of 2025. It took them 11 months. So I don't know why you'd want 11 months for this hanging over the community like that. And they generally take at least a year to a year and a half to review cases like this. I'm responsive to anybody, I talk to, I watched some of your interviews with those individuals on TV8. I think I've talked with just about everyone directly. Part of this is I'm responsive. I've done this I just cleared officers, in December. That was an easy one because the guy came out shooting at him, right? But nobody had any, qualms about me reviewing the case in that instance, so I only do the easy ones and then send the hard ones off to the Attorney General. That's not our role. That's what I'm elected to do. I'm responsive to the electorate, and if they don't like my decisions, that's what elections are for.
The question of, one of the officers involved was Christopher Carlson.
Correct.
Wasn't he not involved in Hank Weimer?
He was involved in the Trinity shooting as well. That is correct.
What shooting site?
The Trinity Health, that was about a year and a half ago. That was the individual who pulled, he had looked like a gun, but it was a lighter, but pointed once again, pointed.
Is he the officer who actually fired the shots in this case? Christopher Carlson?
Officer Carlson was the one who fired the shots.
In this case?
In this case.
And also in the Hank Weimer case?
Correct. He was one of, there's 3 officers in that case, but he was one of them that fired in that case. Officer DeKeevers was the other one. He did not fire shots in this case.
Did the actions back then have any role in this decision?
No, I mean, I knew about it, but it's, they're 2 different instances. I justified that one because it's kind of the same thing. He pointed, and 3 officers fired at that point in time. So, I think it's 2 different circumstances. Just because you're good in one doesn't mean you're going to be cleared in all of them going forward. I base this decision on the facts here.
we can't ignore the fact that Carlson shot Johnson 3 times. Did he really need to shoot him 3 times to avoid that threat?
Well,
What does the law have to say about when it comes to that in self-defense?
I mean, that was in quick succession. So you just not one shot and then 2 or 3 are excessive force. I mean, if somehow he retreated and there was, he's trying to end a deadly threat at that point in time, and once again, you're going to hold somebody to the standard of, your first shot's okay, but it was only 2 hit. But he's trying to end up, and he's clearly running away, retreating, and you're firing. This is the stress of the moment. The adrenaline's flowing. I mean, this is easy again. I've never had a gun pointed in my face. What's that going to do to you? And once again, you get to the excitement of the moment. 3rd shot is too much. Nah, we can't do that.
Do you know
and the law doesn't require that.
GRPD has cleared them as far as internal
I do not know. I've not, like I said, I've not been in contact with GRPD, so I have no idea.
No policy violations.
Not in my review. No.
Becker, when it comes to, obviously, we heard from the interim chief, Trigg, the other day about the 12 officer-involved shootings. You cleared them all. Now this last one, you cleared this one other than sure. What goes through your mind when neighbors are seeing that you're clearing these officers when they're involved in officer-involved shootings?
Well, criticize me for what? What did I do wrong? I mean, that's the thing. Look at, all these, like the last one. Okay, I cleared the last one where a guy shot at him. I mean, so I'm supposed to have a quota of officers I'm supposed to charge because, there's an officer-involved shooting. I mean, the fact is, the law gives great deference, whether it be individuals or police, in terms of this self-defense, and very often, that's what these cases come down to. And so, yes, I've cleared them. I've also charged. I mean, I've charged 3 officers over the course of my career as well for officer-involved incidents. Yes, I've cleared more, but I've also charged them. I can't just look at a tally and try and keep it equal. It's not like, going to a basketball analogy, since it's the Final Four, referees get complained for, all the calls the one team gets. You call them as you see them as they come through, and I'm not trying to keep tally of trying to keep it fair, because that's not my job. I have to base it on the law and the facts.
Now, if these officers were civilians in the same situation that happened, would that make any difference in how you rule?
I don't know how a civilian would be in these circumstances where they've had the ability to make an arrest. They're making an arrest. They're within their rights to make an arrest like that. A civilian doesn't have. So you're comparing apples and oranges there. We're saying, well, civilians, you wouldn't have done the same thing. But I try to give you those examples of where civilians have had guns pointed at them or thought there were guns pointed at them, where I've cleared those civilians as well. So I think it's consistent. This decision is consistent between police officers and civilians. When a gun is introduced into an incident, the law tends to favor the person who may be acting in self-defense. Okay, appreciate it. I think I've answered enough questions, so I think I'll call it a day. Thank you.
Thank you.
Thanks, Chris.
As you just heard, Kent County Prosecutor Chris Becker will not press charges in the death of Daquan Johnson, who died in a hospital following a gunshot by a Grand Rapids police officer. Becker explained his decision and that he cannot prove beyond a reasonable doubt the officer was not acting in self-defense. He compared this to the decision to charge former officer Christopher Schur in the death of Patrick Luea. He said he could not convince a jury then a spent taser was not a dangerous weapon, so he did not think a jury would think that with a firearm like Johnson had at the scene. And we now know family members of Johnson and community advocates were just outside this news conference. We have crews talking to them, getting their reactions to Becker's decision. We'll have more on this live coverage on the situation starting today at 5 o'clock on air and on our streaming app 13+.